Hello, my name is Oles Andrichuk. I'm a lecturer in law at the University of Stirling, UK, and this is Competition on the Merits, podcast on antitrust. Every week I invite an academic or practitioner to share with us some ideas on a specific aspect of competition policy, economics, law and philosophy. I do hope you'll enjoy the program. It would be a treason to say that cartels are harmful for competition. Well, normatively, in some laissez-faire sense, they are of course an embodiment of competition and freedom of contract. And methodologically, in some Schumpeterian sense, they are of course an embodiment of the principle of creative destruction. But even the most consistent libertarian would not dare today to object that some types of such jungle-style economic freedom should be necessarily prohibited. And cartels of course do belong to these instances. So while we may well disagree on where to draw the line, we all agree that eventually the line ought to be drawn. But if there is a consensus that cartels should be prohibited and the wrongdoers should be punished, there is no such consensus on the modes of the punishment. So far the prevailing method is civil liability. Some countries complement it quite successfully with a criminal liability. But there are also some other, more nuanced ways to penalize the companies and individuals involved in cartelization. In a recent paper published in the Journal of European Competition Law and Practice, Andreas Stephan analyzes one of such methods, namely the disqualification orders for directors involved in cartels. I invited him today to Competition on the Merits to discuss this type of liability in more detail. Andreas Stephan is a senior lecturer in law at the University of East Anglia Law School and a member of the ESRC Centre for Competition Policy at the University of East Anglia, UK. He is also a regular commentator on various aspects of competition law for the UK media, and jointly with Professor Bruce Lyons, he runs Competition Policy blog. Andreas Stephan, welcome to Competition on the Merits.
Thank you, pleasure to be here.
And if the following conversation will generate some suggestions on your part, do tell us what you think by emailing to competitiononthemerits@googlesites.com. We are really interested to learn your opinion. This call is not just a formality. And as far as the mere formality is concerned, it goes without saying that the views expressed in this conversation are strictly personal. They do not represent an official position of the institutions which the speakers are affiliated to. So could you provide a working definition of competition disqualification orders?
So essentially, in order for a competition disqualification order to be imposed or to be sought, two conditions have to be satisfied. The first is that an individual must be a director of a company which commits a breach of competition law. And the second is that the court must consider that their conduct as director makes them unfit to be concerned in the management of a company. Now, it can be any breach of competition law, so technically these can be imposed for abuse of dominance as well as cartel conduct. And the application of this is very wide, so the director doesn't have to be directly involved or even know that the infringement is occurring. He simply ought to have known that the conduct constituted a breach.
So explain please when the mechanism has been first introduced in the UK, which enforcement tasks it ought to achieve, and maybe which side effects of the instrument were taken into account at the time of its implementation.
Section 204 of the Enterprise Act amended the Company Directors Disqualification Act 1986 to introduce the Competition Disqualification Order. The Enterprise Act and the Competition Act were part of a broader package of reform to the UK competition law enforcement regime, which included the cartel offence. The deterrent effect of competition disqualification orders is clearly there, but actually the motivation behind having them was the same as the motivation behind the Company Directors Disqualification Act, which is essentially protecting the public and protecting shareholders from directors who are unfit to manage firms. And director disqualification in company law in the UK has been around since the late 1980s.
What is the maximum length of the sanctions the order envisages, and who is responsible for issuing the individual orders?
This is a civil sanction, but it requires court approval. So the Office of Fair Trading, whereas they can impose fines on firms directly, they can't impose a director disqualification. It has to be sought from the court, and that's the High Court in England and Wales, or the Court of Session, I think it is, in Scotland. And a disqualification can be for up to 15 years.
And you also explained that competition authorities can accept a kind of commitment of the individuals involved.
That's correct. So Section 9B of the Director Disqualification Act allows the OFT to accept a disqualification undertaking from a director instead of applying for an order from a court. And this is really just an example of how enforcement is streamlined. In other areas we see forms of direct settlement being adopted. It's just to save time, to avoid having to have the court hearing. Now, the effect of a disqualification undertaking is exactly the same as applying for an order from a court.
Alright, so what are the qualifying conditions in relation to the individuals involved?
Just essentially that they are the director of the company. The main reason for that, two reasons actually. The first one is the motivation behind adopting this. It's about protecting the firm from mismanagement, and the company director essentially holds responsibility for how the firm overall is managed. It's a bit like ministerial responsibility in many respects. One other issue, one of the reasons why it's just directors and not other employees, is directors of companies have to be registered in the UK with Companies House. And so there's a problem with enforcing a disqualification of managers in general, because not all managers are registered, whereas with directors it's very easy to spot if a band director, or it should be to spot if a band director gets another job as a director or manages a firm.
How common the competition disqualification orders are in other mature antitrust jurisdictions?
So the UK is actually almost unique in having such orders. So even in the United States, they don't have a system of director disqualification, and there's no international agreement on director disqualification either, so there's no cooperation.
So after explaining the formal features of the mechanism, let us talk about its very nature. Now, we understand that this type of liability is not as punitive as criminal liability, but indeed it can be really damaging for the individuals involved.
I think that's absolutely right. I mean, in principle, it could actually be more damaging than being sent to jail, because what a director disqualification essentially states isn't that this is an individual employee who happens to have committed a crime. It's an individual who is unfit for what they do. And if we think again about the purpose of it, it's to protect members of the public and companies from these individuals. So that's pretty devastating, in principle at least. That's something that's going to destroy people's careers, reputation. It should affect their employability, how easy they can find another job. Having said that, if we look at individuals in the US who've been imprisoned for price fixing, quite often they very easily find re-employment when they leave jail, despite the fact they've been fixing prices. And the reason for that is that they have great value as human capital. So although they fix prices, they're experts in their field. There might only be a handful of people who have the same knowledge as them. Also, they might be very good managers, apart from the fact that they fix prices. So in practice, I'm not sure how seriously firms would take it. In principle, it should certainly have a deterrent effect. I should point out at this stage that although the director disqualification is a civil penalty, once one has been issued, it's a criminal offence for that individual to act as a company director, or in any way, whether directly or indirectly, be concerned in or take part in the promotion, formation or management of a company.
Then you discuss in detail two main reasons which necessitated the implementation of the instrument. The one is related to the nature of corporate fines, which in some cases do not fulfill the task as effectively as the criminal disqualification order might. And another is that criminal liability so far is not as effective as was expected. Let us start with fines.
Fines, although they seem to be very high, we see fines regularly in the hundreds of millions of euro, they're shown empirically to fall short of the illegal profits gained by the cartels, especially if we take into account that not every cartel is caught, so you have to allow for the fact that there's a probability of detection. Not every cartel is detected. If you were to have truly deterrent levels of fines, optimal fines, under the kind of economic paradigm of deterrence, you would need fines so high that they would put the firm into insolvency. We're talking about in excess of 100% of turnover. At the moment, the cap on fines is 10% of annual worldwide turnover, and the actual fines imposed are closer to 2 to 3%. We also have the same problems that we have which justify criminalisation, which is that fines don't directly punish the individuals responsible. And they also come years after the cartel was instigated. So sometimes 20 years has gone by between when the cartel was formed and when the punishment comes. Even if we just take the gap of time between when the cartel is detected and when the fine is imposed, that can still be 5 years. So, in 5 years, the individuals responsible might have moved on to another firm, they might have retired, they might even have died, depending on how old they are. So that's the problem with fines. So the issue that we have is how to ensure that individuals as well as companies have some form of punishment. And criminalisation, we hoped, would be the best way of doing that. Unfortunately, in the UK, we've been very disappointed in the number of cases we've seen. It hasn't been enough for it to be taken seriously by firms. And so director disqualification is kind of another way of bringing punishment home to individuals.
So basically, criminal procedure is not as effective as one expects it to be.
I'm not saying for a moment that we should abandon criminalisation, but I think it's important to have a broad package of sanctions that you can use and not just put all your eggs in one basket, so to speak. One of my biggest criticisms of the European Commission is they're so focused on corporate fines and they're not even interested in engaging in a conversation about other sanctions that we might consider on a European level. That's been very clear.
So we understand that some of the obstacles are of a purely legal nature. You also explained that others are related to the Commission's regulatory priorities.
So the Commissioner Almunia was asked, would you consider other sanctions such as director disqualifications? And he said no. He said we're just focused on fines. And of course, one of the reasons why he said that is because the modernisation regulation only allows for fines against undertakings. It doesn't allow the Commission. So there would have to be some kind of legislative change. And it is kind of the European tradition that heads of authorities don't question the hand they're given as much as in the UK. So I think it partly fits into that. But I've spoken to many people from DG Comp and nobody seems to have any interest at all in dealing with anything but fines.
And against that background, the OFT published a new version of guidance on the competition disqualification orders.
Yes, that's right. They've made the application wider and they've clarified that the director ought to have known about conduct within the firm. So before this new guidance, it was assumed that the director would have to have some kind of direct involvement in the cartel, or at least knew tacitly that it was going on. But the OFT have made it clear that the application is actually much wider than that, and that the individual simply ought to have known what was going on.
You also mentioned very interesting research made by Deloitte on behalf of the OFT in 2007.
Yes, that's right. So this study that was commissioned by the Office of Fair Trading found that the threat of disqualification was taken very seriously by businesses that they questioned. They were actually asked, both lawyers and UK businesses were asked to list the factors that motivated compliance, so the aspects of enforcement that worried them most, that would most focus their minds to make sure they don't breach the law. They placed the criminal offence at the top, of course, the most serious sanction. And some might have expected fines for the firms to come after that. But actually fines came fourth, believe it or not. So first we have criminal offence, then we have director disqualification, so that's the second most potent sanction. Then we have adverse publicity. So firms worry more about adverse publicity than they do about these enormous cartel fines. And here's the real stinger. Fifth, even lower than fines, is private damages actions. So firms aren't, that could just be a reflection of the fact that there's very few or very weak private enforcement in Europe at the moment. But I suspect it may also be to do with the fact that paying out damages is essentially an extension of the fine. As far as the firm is concerned, it's just about paying out more money. It's not it certainly doesn't mean anything for the individuals.
So basically, companies can perceive fines as costs.
Yeah, and it's amazing. If you look at these big fines that have been imposed on firms, it's amazing the capacity of these big international firms, especially the international firms, to absorb huge fines and just kind of, write them off as a cost. I haven't actually conducted an exhaustive study on this yet, but I've looked at a few firms and looked at their share prices when investigations have been opened and when fines have been imposed. And quite often what seems to happen is that the share price goes down not when the fine is imposed, but when the investigation is announced. When the fine is imposed, quite often share prices go up. And what this reflects is that actually firms care more about uncertainty than they do about the fine. It doesn't matter how high the fine is, as long as they know what it is, shareholders can draw a line in the sand and they can move on. It's the not knowing that's worse. And I was actually at an OFT event where John Fingleton and others suggested this was a good reason to make fines unpredictable, because through uncertainty, you might cause shareholders to worry more. But I'm not convinced that's the case, because even if you make fines uncertain, firms will observe that overall they're very low, compared to potentially the profits they made through the cartel.
Well, at first glance, fines appear to be tremendous, up to 10% of worldwide annual turnover.
10% would be a great leap, but I mean the current levels of 2 to 3% of annual turnover, are very low. So it will have some effect on capital markets, but I don't think it's going to have the huge impact.
So how commonly applicable the instrument is in the UK?
We haven't actually had any disqualifications for competition. The 3 individuals involved in marine hoses were actually disqualified under a separate provision, which basically means that if a company director is found guilty of a crime, he or she is disqualified. So that wasn't actually a competition disqualification order. That was something separate. The other main problems that exist in relation to director disqualification is they only apply to directors. They don't apply to other individuals. So quite often you might get the director disqualified, but the individual employees responsible below him, if there were other managers, not being punished. And the Institute of Directors pointed out that this could mean a disproportionate impact on small and medium businesses. So the smaller the business, the easier it is to show that the director ought to have known that the company was involved in a competition breach. Whereas with larger companies, it's going to be a lot harder to do that because it's a more complicated structure and there's more distance between the director and the alleged conduct. It's also hard to enforce. So once someone has been disqualified, it's easy to check whether they've been a director, because as I mentioned, directors have to be registered in Companies House. But it's very difficult to make sure they don't take up some other senior position within a firm, or, for example, work as a consultant, advising firms as a self-employed person. So, we talked about the potential devastation to someone's career, but let's assume for a moment that firms don't really care whether someone is disqualified. They might still want to employ them. It's difficult to make sure that person hasn't been employed.
You also mentioned there is a particular difficulty associated with its compatibility with leniency programs.
The problem that we have, apart from the fact, by the way, that if you're disqualified you can move to another member state, because we don't have European disqualification orders, it's just within the UK. But the main problem that we have is, in the consultation, the OFT asked businesses what they thought about the relationship between leniency and director disqualification. And the OFT became convinced by these responses that if you disqualified directors of firms that cooperated through leniency, it would discourage firms from coming forward in the future. So I very firmly believe that the only director that should receive immunity is the director of the revealing firm, the first firm to come forward. I think the directors of all the others should be disqualified. But because they quite often rely on the directors to help the firm with cooperating with the authority, the OFT felt that wasn't appropriate. Now, of course, this completely sinks any deterrent effect that the competition disqualification order can have, because directors can carry on colluding or knowing that collusion is going on, safe in the knowledge that as long as they cooperate once an investigation is opened, then they won't have a director disqualification order placed on them. So it completely takes the bite out of the sanction. And I can't envisage a case where the OFT would successfully seek a competition disqualification order, because nearly all firms in cartel cases cooperate, once the investigation has been opened, in order to get the fine down through leniency. I think this concern has been overblown by the consultation respondents, a lot of whom were lawyers and businessmen. And I think in practice, one of the ways in which you could safeguard leniency is by reflecting the level of cooperation and the length of the disqualification. So firms that have really cooperated but who missed immunity, you might only seek a disqualification of 3 months or 6 months. You don't have to go for years.
Finally, in the last section of your paper, you analyze whether the cartel disqualification orders should be recommended to the European Union. How realistic this option is, in your view?
Well, I would say it's probably very unrealistic. Actually, there's a very good paper by Powell and McKelvey, who look into the various options, possibilities, or the basis on which you could have European disqualification order. But the fact is that in the EU, we haven't even got harmonisation of disqualification in company law. There are many jurisdictions that don't have disqualification at all. The ones that do have it, they don't coordinate with each other to make sure that a director disqualified in one country can't move to another. So at the moment, if you're disqualified in the UK as a director, you just move to Ireland, or move to Dublin or Brussels or somewhere and get a job there. As we mentioned earlier on, also Commissioner Almunia has made it clear that he's not seeking any sanctions for individuals at all, and that this would in any case be inapplicable with Regulation 1/2003, which concerns only undertakings. So the problem we have is that it would require some kind of legislative change on the European level. Regulation 1/2003 doesn't contain in it any basis for us to impose sanctions on individuals. Now, if there was the enthusiasm for this, I don't see technically why there's any reason why it couldn't happen, to have a European-wide disqualification order. In Powell and McKelvey, they outline different articles that could be used as the basis. I think the most promising is probably Article 50. So this concerns freedom of establishment, and it empowers the European Union to adopt, to the necessary extent, the safeguards which, for the protection of the interests of members and others, are required by member states of companies or firms, with a view to making such safeguards equivalent throughout the Union. So if we remember that the purpose of disqualification is to protect EU citizens, I think that very neatly fits into Article 50. So if there was the desire to adopt a European disqualification order, I think that would be the sound basis for it.
So, assuming that the mechanism were implemented at the European level, what main advantages would it bring to Europe?
There are two potential advantages. The first one is that it will increase the effect of a disqualification, because it won't be easy to simply move between member states to avoid the effect of, say, a UK disqualification order. It will also redress this very bizarre situation we're in, whereby if you're involved in a local cartel within Ireland or within the UK or within Germany, you're actually likely to be more severely punished than if you're involved in an international cartel that's pursued by the European Commission. So in Ireland you could face jail, in the UK you could face jail. In Germany, for example, if you're involved in bid rigging, you could face jail. But because the European Commission hasn't shown any leadership in trying to help national sanctions against individuals complement EU competition law enforcement, because of that, if you're involved in a case that's investigated by the European Commission, I don't think you have very much to worry about as an individual at all. The European Commission won't hold its investigation while there's criminal proceedings on the national level, and it's unclear that any mechanisms are in place for the two to complement each other.
You also mention a potential conflict of interests between the Commission on one hand and national antitrust authorities on the other.
A lot of it is that they worry about stepping on the Commission's toes, because although the Commission is meant to be an equal partner within the European competition network, at the end of the day they are the one that calls the shots for EU competition enforcement in any rate. I think it also looks a bit, I think the Commission is worried it would undermine their legitimacy if member states complemented their enforcement, because the problem is it would only be in some member states. The UK and Ireland would be the main member states probably.
So to sum up, how would you describe the main message of your paper?
The main message of the paper is that director disqualification is a potential second best to a criminal offence, and I think it's something that's important to have available. In situations where we're having problems with the criminal offence or where criminal sanctions are not appropriate. There may be cases where the conduct doesn't deserve criminal sanctions, but some kind of punishment needs to go onto the individual. I think the OFT's approach to leniency is wrong. I don't see any point in having disqualifications if you're not going to grant them whenever people cooperate, because of the level of cooperation we tend to see in cartel cases. And I think more needs to be done to harmonise disqualification within the EU. There was actually some movement towards it about 5 or 6 years ago among company lawyers to have a single sort of disqualification regime, but nothing much seemed to happen to it. I think there was a green paper on it. That was pretty much it. So I think more efforts need to be made, perhaps with some pressure from competition lawyers on company lawyers to kind of get things moving.
Andreas, Stefan, thank you for sharing with us your fruitful ideas.
Thank you very much. It was a pleasure.
You've been listening to the Competition and the Merits podcast on antitrust. And if you enjoyed this program, Why don't recommend it to your students? Please join us next Tuesday. Another week, another podcast on antitrust.